by notes of motion, specifically seeking for two orders. A, hearing of criminal session number 335 of 2020, B state pending resolution of constitutional petition number 031 of 2025. B, the applicants be released from custody and be granted bail. I have a detailed ruling, but I will go direct to the determination of the court. And then the parties will get the ruling. I have put into consideration all the oral submissions of both parties, but majorly this application is seeking for one, stay of criminal session number 335 of 2025, pending determination of constitutional petition number 031 of 2025, and two, that the applicants be released on bail. From the onset, I find it necessary to draw a clear distinction between stay of proceedings as a result of constitutional reference and constitutional petition. I have had the opportunity to look at the case of Charles Onyango Bo and Andrew Mwenda versus Attorney General, Supreme Court Constitutional Appeal number 2 of 2022. I will base on Justice Mulenga, who stated in that case that under Article 137 of the Constitution of the Republic of Uganda, any person may access the Constitutional Court in one of the two ways. One, a person may petition the Constitutional Court directly for a declaration that any law, act, or omission is inconsistent with the Constitution. Second, that a party, any proceedings in the court of law in which a question arises as to the interpretation of the Constitution may request court to refer the question to the Constitutional Court for a decision. This case went ahead to say that where the court refers a question that arises in proceedings before it must await the decision of the question by the Constitutional Court. This case was equally relied on by counsel for the applicants in their oral submissions. In the instant case, this application before me, it is not in dispute that the applicants have petitioned the Constitutional Court directly by a petition which does not warrant an automatic stay, but rather seeks for a remedy in this application which is discretionary and must be exercised judiciously. It is therefore not true that the stay is automatic, as counsel Elias collaborated so much on this court. I have looked at another case which brings out a position of the law, and this is constitutional petition number 50 of 2012, Geoffrey Kazinda versus Attorney General. In this case, it was observed that, however, where a party to the proceedings before a court of law petitions on his or her own to have the Constitutional Court determine some question to do with the proceedings before that court of law, it does not automatically follow that the court has to stay the proceedings before it, pending the determination of the question. A party to the proceeding petitions the Constitutional Court determined. In such a case, the issue of whether or not to stop the proceedings pending determination of the petition, in my view, appears to be left to the discretion of either the trial court or the constitutional. In the case of Omar and 10 others versus Attorney General, consolidated constitutional petition number 55 and 56 of 2011. The learned justices of the Constitutional Court guided that discretion to stay criminal proceedings must be exercised sparingly and carefully with consideration of the gravity and seriousness of the offense. I also looked at section 17, clause 2 of the text. This section 17(2) provides that with regard to its own procedure and those of magistrates' courts, the High Court shall exercise its inherent powers, A, to prevent abuse of process of court by curtailing delays in trials and delivery of judgments, including the power to limit and discontinue delayed prosecution. C, that to ensure that substantive justice shall be administered without undue regard to legalities. I have addressed my mind to section 61 of the Trial on Indictment Act. This section 61 brings out the issue of pleading to indictment. It clearly states that the accused person to be tried before the High Court shall be placed at the bar, and the indictment shall be read over to him or her, and the accused person shall be required to read instantly the indictment and sections of the law. In my opinion, and in simple terms, pre-taking enables court to ask an accused person if he or she admits or denies the charges. Simply to require a person to say yes or no. A stay of proceedings, in my considered view, and bail application, even if this honorable court is to grant, which is the right to the accused or the applicants, to me, it would make sense after the applicants are taken the plea, and court is in a position to know whether the accused persons, in this case the applicants, have admitted or denied the charges other than putting the pretext. According to the court report, which I have had an opportunity to go through, applicants before this honorable court were committed on 29th May 2025. And the matter was fixed for pre-taking on 1st September 2025. But to date, applicants have never taken plea or pleaded the charges against them. Applications after applications have been filed, which this court has managed to dispose of. But in my view, this has made plea-taking difficult. It is therefore my view and opinion that for the interest of justice to both the applicants and the respondent, the applicants should proceed to take plea. If they so wish, they can even apply for bail after taking plea. I am aware and alive to the constitutional right of presumption of innocence of the applicants until proven guilty. So in the final result, and for the reasons stated above, this application for stay for proceedings in criminal session number 335 of the 2025 and the order for releasing the applicants on bail is not granted, it is denied. I will therefore direct that applicants first proceed to take plea immediately.